Well, welcome, everybody. My name is Harvey Ryder. I'm an attorney here at Stinson LLP, so I want to thank my firm for making the facilities available, and I also want to thank our co-sponsors of our continuing series of lunch and learn programs, the American Association of Jewish Lawyers and Jurists, the Jewish Federation of Greater Washington, SEDIC DC, and the Jewish Community Relations Council of Greater Washington. So I want to thank, again, everybody for being here, both in person and online. For those of you in the room, we have microphones near you, and we'll have a chance for questions at the end of our talk today. And for those of you online, please just enter your questions in the chat or Q&A box, and we'll take those up as well after the talk is concluded. So today we're going to be talking about a look back at the last Supreme Court session and the upcoming one. And we're going to start first. I want to start by thanking our guest here today, Mark Joseph Stern. And you have his bio if you've enrolled, but I think it's short enough. I'm just going to read it to you. Okay. So Mark is a senior writer at Slate Magazine covering courts and the law, and he's co-host of the Amicus podcast. He's based here in Washington, D.C. In fact, he bicycled over today, and he's covered the Supreme Court, other federal appellate courts and district courts, and state and local courts for more than a decade. He's a native of Tallahassee, Florida, and holds a law degree from Georgetown and an undergrad degree also from Georgetown. He's a member of the Maryland Bar, although I understand he's also applying to join the DC Bar. And his areas of expertise include LGBTQ equality, reproductive rights, criminal justice, and Supreme Court jurisprudence. And the last we're going to hear quite a bit about. Mark is the author of a 2019 book, American Justice: The Roberts Court Arrives, published by the University of Pennsylvania Press. And he has co-authored several law review articles about free speech, gay rights, and transgender equality. He and his husband welcomed a son in 2023 and are the proud caretakers of, get this, 1 rescue dog and 3 adopted birds. I mean, I thought it was a big accomplishment. I thought it was an accomplishment that we had a goldfish for 8 years.
And one of those is a parrot who talks, by the way, which is a whole other story. Yeah. Thank you so much. Before we start, I just want to check in and make sure that everyone can hear me online. I know many of you are joining online, so someone send up a distress signal if we cannot be heard. But otherwise, we're going to move forward. Okay.
I had a text exchange with somebody that I think we're good.
Great, thank you. Hello, we feel your presence in the room, online guests, and thank you everyone in person.
So I mentioned at the outset that we're going to talk about the past Supreme Court term and upcoming cases. But before we get into that, I know everybody's probably been reading about the shadow docket. That was a term that Professor William Bowd at the University of Chicago coined about a decade ago, and it refers to the emergency docket. And you can't go a day without turning on the TV or going online and find out some other shadow docket case that the court has decided. So I thought, Mark, we'd start first with a basic question. What is the shadow docket?
Yeah, so when Will Bowd coined the term a decade ago, he was talking about all of the decisions that the Supreme Court makes that are not rulings in argued cases on the merits. So we all know, like every June, the Supreme Court convenes at 10 a.m., hands down these decisions. That's the regular docket. He was talking about everything else that it does, and that included denials of cert, it included emergency orders, and it included a few other things that the court does summarily. I think when we use the term today, we're mostly talking about the emergency docket. So the emergency docket is the series of orders and decisions that the Supreme Court issues in cases that have not been fully briefed and that have not been argued at the court. These are sort of summary dispositions of cases that usually, though not always, as we'll discuss, have some kind of time crunch to them. So the Supreme Court feels it needs to act quickly. Up until about 7 years ago now, the shadow docket was very, very small and a tiny, tiny part of the Supreme Court's work. The Supreme Court very rarely granted relief on the shadow docket. Some of you might remember that shortly before his death, Justice Scalia voted in a major shadow docket decision to block the Obama administration's Clean Power Plan. That was a huge deal because the court almost never intervened at an early stage like that and issued a kind of unsigned, unreasoned order blocking a federal program. Today, that would have just been another blip because the Supreme Court does that stuff all the time. The shift really changed when Justice Brett Kavanaugh replaced Justice Kennedy, when Justice Barrett replaced Justice Ginsburg, and now especially as Donald Trump has entered his second term. So when we talk about the shadow docket today, we'll really be talking about the emergency decisions that the Supreme Court orders because it feels that it needs to leap in before the lower courts have finished their work.
So let me ask you a little bit about one of the ones that has most recently been in the news, those roving ICE aides, ICE undercover, I don't know how you would call it, how you describe it, picking up people because they looked Hispanic or spoke Spanish.
So yes, this is the most recent treat, some might say. I say that with bitterness and irony, to be clear, that the Supreme Court has given us from the shadow docket. This is a case that arose after the Trump administration targeted Los Angeles earlier this summer for roving ICE patrols in something called Operation At Large. And the goal was to identify and arrest as many undocumented immigrants as possible by targeting people and locations suspected of illegal conduct, including simply being in the country unlawfully. A number of individuals who were caught up in these raids sued, including multiple American citizens who were tackled to the ground and held at gunpoint with assault weapons in their faces, forced to prove American citizenship or be thrown into the back of a van to be transported to indefinite detention in another state. So the stakes were high. And a federal district court ruled that aspects of Operation At Large violated the Fourth Amendment. So she said, this operation is not inherently unconstitutional, but under the Fourth Amendment, ICE agents cannot arrest people based on the following four factors alone or in combination. And those factors were appearing Hispanic, speaking Spanish or Spanish accented English, working in occupation associated with immigrants, or being at a place associated with immigrants. So that includes like car washes, Home Depots, bus stops. So the judge said you can keep arresting immigrants, but you cannot use these factors because that is essentially racial profiling, and the Constitution does not allow that. What the Supreme Court did on Monday was lift that injunction, and the Supreme Court freed ICE to resume using those factors in its raids in Los Angeles. The court did not tell us why it did that because, as we'll discuss, one of the hallmarks of the shadow docket is that it all happens in the shadows and the Supreme Court doesn't explain itself. Usually the Supreme Court does not give us any reasoning, does not give us a signed ruling. It doesn't even give us a vote count. We assume that this decision was 6-3 because the 3 liberal justices dissented, but we don't really know because justices can dissent and then not publicly display their dissent. But I think it's probably safe to assume it was 6-3. And because we don't know why the majority lifted the injunction, other lower courts don't really know what the state of the law is. I mean, until Monday, it had seemed like a pretty clear rule that you couldn't arrest someone because they look Latino. And in fact, it was just a few years ago that the Roberts Court flaunted its great commitment to racial equality by declaring that race couldn't even be a factor in college admissions at universities across the country. But now it seems that the court has decided that race can be a factor when masked ICE agents are deciding who they want to violently arrest. That is, I think, what we can deduce from this decision. A very bitter dissent by Justice Sotomayor, I think righteously passionate in saying that this has created a kind of second-class citizenship for Latinos. Really, the implication of the decision is that if you are Latino, you appear Latino, you speak Spanish, you need to carry around proof of citizenship at all times, because ICE can detain you and demand that proof and take you somewhere else and detain you there indefinitely until you provide it. So this is sort of constitutionally blessing the papers, please regime that Trump wants to set up, and doing so, again, without full briefing, without oral argument, all sort of in a fly-by-night way that I think doesn't make the court look particularly good to the public.
So what, Kavanaugh filed a concurrence of sorts in that case, didn't he? You want to talk about that?
So it's interesting. So Kavanaugh has been the most responsive to criticism of the shadow docket. He perceives that people don't like this, and he is trying to justify it. So he keeps writing these opinions where he's trying to justify it. He's doing these public talks where he says, like, this isn't really bad. Let me explain why. And in this concurrence, he said, okay, I'm going to tell you why I voted as I did. But his reasoning, I think, really does not withstand much scrutiny because, again, he claimed that race can be a factor in arrests just a few years after saying that race cannot be a factor in college admissions. It seems like a pretty perverse system where the government can punish you for your race, but cannot give you a benefit because of your race. Kavanaugh didn't bother to try to square that circle. He grievously misrepresented the facts on the ground. You know, this was a district court case first. And so there's a factual record here that had been compiled. And it showed that ICE agents were engaging in racial profiling and using great acts of violence when arresting people. And he claimed that all they were doing was briefly stopping individuals, and that once individuals made clear that they were US citizens, they were let go and allowed to go along their way. I mean, that is just not true. And the factual record shows why, and it's pretty much uncontested. And then he also tried to say, look, we're doing our best under tense circumstances. We're trying to be neutral judges calling balls and strikes. So give us a little bit of a break here. I mean, there is a kind of defensive tone in his concurrence that he's been striking over and over again. And that, I think, prompted Sotomayor to issue a pretty sharp rebuke. And she and Justice Jackson and Justice Kagan now keep doing this, where they're saying, look, if you feel like you're working under stressful conditions, you aren't really sure what the law is, you're having to do this really fast, maybe you shouldn't intervene at all. Maybe the answer is to do what this court did for the first 200 some odd years of its existence and wait until this case reaches us properly on the merits instead of intervening prematurely. But that did not convince Kavanaugh or anybody else.
I'm trying to remember, did Kavanaugh say anything? And I comment, if you want to comment briefly on this, whether someone who's affected, it doesn't seem to me like it's going to be much of a recourse with someone who's been rounded up to bring a civil suit for, violation of their civil rights.
This was the part of the concurrence that actually irritated me the most personally. He wrote that, yes, in some isolated instances, it appears that ICE agents have used violence, but he said, in those cases, victims of violence can go to federal court and receive remedies. And he said, I support that, and I agree with the dissent that they should be able to do that. The problem is that Justice Kavanaugh himself cast the fifth vote in a notorious 5-4 decision that essentially insulated immigration agents from civil suits under federal law a few years back. And then he joined another decision even more recently that further slammed the door shut on civil rights lawsuits against immigration enforcement for violating constitutional rights. So Kavanaugh has played a major role in ensuring that victims of ICE's violence cannot go to federal court and receive remedies if their rights have been violated and they've been subject to brutality. And here he is claiming that that option is still available. And I feel like he's trying to pull the wool over people's eyes. But anyone who's actually going to read this opinion probably knows better.
So, Mark, I know we're talking for a while now about the shadow docket, but I think I want to stick with it for a little while longer. Maybe you have some other cases, examples that you would like to talk about of how the shadow docket is operated and how it's affected everyday lives?
Well, I mean, where do you want to start? Because there are so many we could do. That's a very broad question. Yeah, I think one area that I think also illustrates this and the dynamic going on here is the firing cases, the way that the court has used the shadow docket to let Trump seize control of the executive branch. So, as I'm sure many of you know.
So why don't you let's start with you're talking about Humphrey's executor
yeah.
and its potential likely demise.
Yeah.
Okay.
Oh, it's dead.
Yeah.
It's dead. We just haven't held the funeral yet.
Right. So why don't for those of you who are listening or here today, why don't you just briefly describe what that 1935 decision was about?
Yeah. So 90 years ago, I'm sure most of you know this, the Supreme Court unanimously ruled that Congress could restrict the president's ability to fire heads of agencies, even if those agencies interpret and enforce federal law, and even if they are technically situated within the executive branch. It was the decision called Humphrey's executor.
And that was a very conservative court that was angry with President Roosevelt.
Well, it was a very conservative court that was mad at President Roosevelt, and that explains the right flank. But this was also a decision joined by like Cardozo and Brandeis, and this was not a controversial decision within the judiciary at the time. The court said, look, like this has been a practice for a long time, and actually scholars have shown that it has. The very first Congress actually created an independent agency called the Sinking Fund Commission. Go into all this detail, but it's sort of irrelevant because originalists don't actually care about this history. But the court said, agencies need to be able to do their work with some degree of remove from partisan interference, because that case was about the Federal Trade Commission, the FTC. The FTC is trying to enforce federal trade law. It's not trying to enforce the president's personal vendettas against corporations or reward corporations that he likes. So it's fine for Congress, which the Constitution allows to structure the executive branch. This is something that's frequently forgotten. Congress gets to structure the executive branch, and in doing so, it gets to create some insulation for leaders of agencies that the president may not like. That was the law until 3 months ago. When Donald Trump came back into office, he started firing the heads of agencies left and right, including many who had protections against removal. Now, to be clear, the Roberts Court had rolled back Humphrey's executor to some degree and allowed the president to fire single director heads of agencies. There were only a few of these. So like the head of the CFPB, for instance. And the Roberts Court said, well, that person has total control over the agency. They wield a lot of executive power. So we're going to allow the president to fire them. But still, these multi-member agencies like the FTC, the FCC, the SEC, the National Labor Relations Board, the Federal Reserve, those can still receive the protections of Humphrey's executor and the protections that Congress has given them. So Trump came into office and he said, well, I don't agree with that. And he just started firing people. These are people who are guaranteed protection against removal by Congress without good cause. And Trump didn't pretend to have good cause. He just said, I'm firing you because I think I have the constitutional right to do so. Just purged Democratic commissioners from all of these agencies. And some of them sued and said, well, wait a minute, we have protections under federal statute, and the Supreme Court's precedent from 90 years ago says that those are still good law. And the lower courts agreed and said, yeah, I mean, we can't overturn Humphrey's executor ourselves. We're lower courts, so we still have to apply it. And they reinstated these commissioners. And now, twice, and probably a third time soon, the Supreme Court, nonetheless, by 6-3 votes, allowed Donald Trump to fire commissioners at agencies who were absolutely protected against removal, to strip them of their jobs years before their terms were set to expire, at the National Labor Relations Board, at the FTC. This is one case that's pending now, which was actually the case involved with Humphrey's executor, at the Merit Systems Protection Board and other agencies. And I think that is incredibly disturbing, because what the court did in those decisions was really overturn precedent. You know, there's no way to square those actions with Humphrey's executor. So the court was clearly just killing off a precedent of itself, but it didn't explain why. It didn't tell us like, okay, well, this is a 90-year-old precedent, but we think it's time to go. They just sort of dashed off a few unreasoned cryptic lines about how these officials wield executive power, so we think they should be able to be tossed, and then left the lower courts to guess about the scope of that judgment. That is a really bad way to run a railroad. And we're seeing that with the confusion that the lower courts have been thrust into now, where there are all these other agencies where, like the Federal Reserve, where Trump is trying to fire people, and they say, we don't know what to do. Do we follow these cryptic orders from the Supreme Court from 3 months ago that don't make any sense? or do we follow the 90-year-old precedent that had seemed to be binding on us until just about yesterday?
So let me ask you a question, because we have several Jewish organizations sponsoring this. So several of the people that the president has fired were at the EEOC
Yes.
and the Merit System Protection Board. In fact, he fired enough of them so that neither of those agencies have a quorum.
Yes.
So what do you do if you're a Jewish employee in a private firm or working for the government and you think you've been the subject of racial discrimination? What's your recourse?
So you have no recourse, more or less. And that's also true of people who feel that their union rights have been violated, whether in the private sector or in the public sector, because the FLRA, which deals with public sector unions, doesn't have operating capacity, and the NLRB, which deals with private sector unions, also doesn't really have operating capacity right now. And the EEOC has been kneecapped as well. So has the Consumer Product Safety Commission. So one of, I think, the goals of these firings wasn't just to purge the Democrats and say, you're my political enemies, you're gone. It was to dismantle the agencies themselves and paralyze them and prevent them from doing that kind of work. And so, unfortunately, the answer for a lot of these employees has been, you can't do anything at all because the organizations, the bodies that are supposed to protect you have been taken offline. And it's a really kind of...
It affects employers too, though, if they think they've been, let's say they face an unfair labor practice charge and they think it's invalid, they're left hanging too, aren't they?
Well, and yet the employers aren't largely complaining about this for whatever reason. They aren't the ones who are griping about this. But I think it's important to sort of lay out like the pincer movement that's going on here. Let's focus on the Merit Systems Protection Board. Yeah. So this is a board that hears claims of unlawful terminations by federal civil servants. You might have heard that there are a lot of those these days. A fair number of civil servants, I think numbering like in the tens of thousands now, have been fired. Many of them had some level of protection and due process rights against firing, and yet they were still taken off the job. So they went to federal court and sued. And they said, we had our rights violated, we want our jobs back, or we want some other kind of remedy. The federal courts are saying, and by the way, the Supreme Court has said this as well, no. You have to go through the agency that looks out for your rights before you sue in federal court. Well, what agency is that? The Merit Systems Protection Board. Well, guess what? It doesn't have a quorum. It can't adjudicate anyone's rights. And the guy who is supposed to investigate these violations of civil service law, the Office of Inspector General, the Office of General Counsel, the Office of Special Counsel, which is different from the Robert Mueller thing, to be clear. The Office of Special Counsel, he was sacked by Donald Trump in his first 2 weeks of office. So all of these agencies that are supposed to be protecting workers, they have had their guts sort of cut out. And yet federal courts are still telling employees, if you want to protect your rights, you have to go to those agencies. And when district court judges say, they can't go to the agencies, they have to come to us because the agencies basically don't exist, the Supreme Court overturns the district court's decisions. So it's a really bad spot for employees right now.
So just very quickly, because I know we've got other things we want to cover. The president's argument, if I understand it correctly, would be that his right to fire derives from his authority under Article 2.
That's right.
But would the counter argument be where he's disabled the agency entirely, that it's a violation of Article 1, that Congress created an agency they expected to actually operate?
Yeah. And I think the best example of that is the Department of Education, right? So Congress created the Department of Education. It staffed the Department of Education. It appropriates money to the Department of Education. It's created all of these offices within the Education Department that say, you have to perform these statutory duties, right? Donald Trump came into office and said, I want to dismantle the Education Department. And so he attempted to fire more than 1,400 people and to shutter many, many offices within the agency that perform these duties that Congress assigned, including civil rights investigation and enforcement, disability rights, like student loan processing, all of this stuff that's sort of key to the agency's mission. It couldn't be done because those offices had been shuttered because there was no one there to run them. So a bunch of employees sued, as did people who were affected by these shutdowns. And they made their argument that you just made, that this was a separation of powers violation, that at a certain point, if the president abuses his executive authority to this degree, he is encroaching upon Congress's Article 1 prerogative to create executive agencies and dictate how they will be run. And the lower courts agreed and blocked the terminations. And they gave concrete examples of how these offices within the education department would be literally unable to carry out their statutory duties because there was no one to run them if these layoffs went through. But the Supreme Court reversed those decisions by a 6-3 vote. So we don't know why. It didn't explain itself.
So this is one last quick statistical question before we move on to last term's decisions. Do you know how many shadow docket emergency appeals the government has filed, let's say, in the last year, and how often have they won?
I can tell you from the beginning of the Trump administration, it is more than 20 shadow docket applications, and the Trump administration has won 18 of them. So it has only lost a tiny, tiny percentage. And even still, sometimes those losses are qualified losses. The Supreme Court will give the Trump administration sort of toss it a bone. That was the case, and you may be familiar with the Kilmar-Abrego-Garcia affair, where the Supreme Court sort of told the Trump administration, you should probably bring this guy back, but you can take your time doing so. You know, we count that as a loss for Trump. And so it raises the statistics of the number of times he loses, but like it was still kind of a win for him.
So I know people may have, we can come back to questions about the shadow docket, but let's talk about last term. And the first case I wanted to ask you about was Trump versus Casa. I think most people thought that was going to be a decision about the president's executive order ending birthright citizenship, but it turned out the court saw it as a different kind of case.
Yeah, that's right. So this case involves Donald Trump's executive order issued on January 20th to end birthright citizenship for the children of undocumented immigrants, as well as the children of temporary immigrants, which included visa holders, people on like an H-1B visa, an education visa, the children of dreamers, the children of a bunch of other groups of people who are allowed to be here, but with a finite limit. That obviously violates the 14th Amendment. Like the very first sentence of the 14th Amendment, which we fought a civil war over, says that all persons born in the United States are United States citizens. It's crystal clear. The Supreme Court has affirmed that interpretation for more than 120 years. It has said very, very clearly that the children of immigrants receive this fundamental right. So a bunch of different groups sued. Mothers who were about to give birth, organizations that represented those mothers and other children, states who wanted to ensure that children born within their borders would still be citizens, and 3 different district courts issued nationwide or universal injunctions that blocked the rollback of birthright citizenship across the entire country in every way. The Trump administration knew that it would probably lose on the merits, so it didn't appeal the merits to the Supreme Court. It didn't go to the Supreme Court and say, please give us a win on birthright citizenship. It only appealed the scope of the injunctions. And it said, we think that these injunctions are overly broad and need to be rolled back because they violate the Constitution and the Judiciary Act of 1789 and a bunch of other things. I was surprised when the Supreme Court agreed to take up that question because over 4 years of Joe Biden's presidency, the Justice Department repeatedly asked the Supreme Court to end nationwide injunctions, said, please, these are being abused. A single district court should not be able to determine policy for the whole country. You know, constantly when Joe Biden would try to do things, these judges in Texas and Louisiana would issue these nationwide blocks. One judge famously tried to ban mifepristone, the abortion pill, nationwide. The Biden administration begged the Supreme Court to end nationwide injunctions, and it refused under Biden. It said, no, we don't want to consider that issue. And in fact, the conservative justices on the Supreme Court repeatedly allowed nationwide injunctions against Joe Biden to stand for 4 years and on a bunch of really important issues, including immigration and border enforcement. The Supreme Court allowed those injunctions to stand. And yet, just a few months into Donald Trump's second term, the Supreme Court suddenly decided that it was time to decide the issue of nationwide injunctions. And when it issued a decision, it turned out that the Supreme Court had decided it was time to end nationwide injunctions. And that less than 6 months into Donald Trump's presidency, universal injunctions or nationwide injunctions were out the window. They violated, according to the court, the Judiciary Act of 1789. It is not within the power that Congress granted the district courts. And so the Supreme Court told the lower courts, you can't do these anymore, and you have to roll back the injunctions against birthright citizenship. So that is where we are with that case.
So I want to ask you about a footnote that I think has been overlooked in that, and what you think might be the significance of it. The footnote says, you mentioned the case was decided on an interpretation of the Judiciary Act.
Yes.
But there's a footnote that says nothing we say here should be construed as any ruling on the scope of the court's authority to deal with matters arising under the Administrative Procedure Act and its authority to set aside agency decisions.
Yes, indeed.
And several of the justices, Justice Jackson, Justice Roberts, and Justice Kavanaugh have all said set aside means set aside entirely. It doesn't mean just for the plaintiffs involved.
Right. Can we get into the weeds a little here?
Yeah.
So, I mean, I think my colleagues in the media sometimes muddle this issue, but I think it's really important to talk about. When we're discussing district court decisions with nationwide scope, there's universal injunctions, and then there's universal vacatur, which is sometimes called the set-aside power. Universal injunctions are drawn from the Judiciary Act of 1789, though no longer, and the sort of equitable powers of the district courts. Universal vacatur is taken from the Administrative Procedure Act, and it's taken from a subsection of the act that says that when a district court finds a federal rule or regulation to be unlawful, it may set aside that regulation. And the courts have been interpreting that to mean that when a district court thinks that some regulation is illegal, it can block it nationwide by vacating it in its entirety. So this is something that the Supreme Court in the CASA decision suggested is still on the table. The court did not directly address it, but it suggested that you can still, as a district court, issue this universal vacatur of something in the Federal Register that the administration has published, because that is allowed by Congress under the APA. I think this is a very perverse state of affairs if it holds, because it seems to me that universal injunctions are best understood by their supporters as a tool against illegal executive orders. That's basically what they're best used for. When Trump just issues some executive order against birthright citizenship that repeals the 14th Amendment, you kind of need a universal injunction to say this cannot be enforced anywhere, anytime. But with universal vacatures, those are generally issued when the administration has tried to do something the right way, when it's gone through notice and comment rulemaking, when it's published in the Federal Register, when it's responded to all of the public notes and comments about why it's doing what it's doing and why it isn't doing something else. Like when it's slogged through all of the requirements of the APA, then that can still be blocked universally. But the dashed off executive order that Donald Trump signed with a Sharpie and thought about for 45 seconds, that can't be blocked universally. That can only be blocked in some very limited way that the Supreme Court is sort of cryptic about exactly how broad it is. So it just strikes me as odd that the court would create these two avenues for relief, where when the president does something that's lawless but slapdash, it can't be blocked nationwide. But then when the president does something that goes through all the right channels and is done all the right ways and complies with every jot and tittle of congressional prescribed rulemaking, that can still be set aside in an instant universally nationwide by a district court.
I'm a little more optimistic than you are in that because agencies also act skipping notice and comment.
Yes.
And a lot of what the president does through executive order is carried out through administrative agencies.
That is true.
So that's another way that somebody can try to, seek to enjoin an agency's action that's unlawful.
Well, so I mean, that's true. we don't need to debate this,
Yeah.
but like, if you think about it in the case of birthright citizenship, the way that sort of cashes out is that this is going to a bunch of different agencies to implement. The Department of State isn't allowed to issue passports, and they're going to create some reg for saying we're no longer giving passports to the children of undocumented immigrants. The Department of Homeland Security is going to change who is considered deportable, right? That like different agencies are going to create different regs, and now all of those would have to be targeted for universal vacatur rather than having one injunction at the outset that blocks the whole process. But yeah, I take your point.
So let's move on to, if you want to talk maybe briefly about the U.S. versus Scrimetti case.
Yes. So this was a case that challenged the Tennessee ban on gender affirming care for minors. Tennessee is one of almost 24 states that now bans minors from accessing puberty blockers or hormone therapy to align with their gender identity. I just want to be clear, this case did not involve surgery. There was a lot of talk about surgery. This was not a challenge to surgical procedures or their banning. This was only about hormone therapy. The state said that the goal of this law was to make minors appreciate their sex and to prevent minors from transitioning from one sex to another to ensure that they would stay within the sex that they were assigned at birth. The United States, under Joe Biden at the time, as well as private plaintiffs, filed suit and said, this law uses the word sex 19 times. The stated goal of the legislature is to prevent children from transitioning from one sex to another. It sure looks a lot like sex discrimination. And it kind of seems to us like it should be at least assessed under heightened scrutiny as sex discrimination under the Equal Protection Clause. The Supreme Court disagreed in Scrimetti by a 6-3 vote. The Supreme Court held that this law was not sex discrimination whatsoever, and so it did not need to be assessed under a heightened scrutiny standard. And the court's reasoning essentially went like this: boys can't become girls, but girls also can't become boys, so both genders are subject to the same restrictions. Therefore, this does not classify or discriminate on the basis of sex, and it's only subject to rational basis review.
There was a decision that came out by the Fifth Circuit sitting in Bank.
Yeah.
And that one, I think, involved how you would apply this case. You mentioned that the Scrimetti case was a Equal Protection Clause case, but this second case was a statutory case involving what the meaning of on the basis of sex is.
Mm-hmm.
So you want to talk briefly about that case? I think it's pretty significant.
Yeah, Lang versus Houston County. It's in the 11th Circuit, the old Circuit.
11th Circuit.
Yeah. So this was a case in which an employee of the county was denied access to gender affirming care through the state-funded insurance program. And she sued under Title VII and said, this is discrimination because I am transgender. You are not allowing me to access medical procedures that I seek because I am transgender. And so you are violating Title VII. It seemed like a strong argument because, as we talked about last year, and as I'm sure you all know, in 2020, the Supreme Court actually held that Title VII does prohibit discrimination on the basis of transgender status. This is a case called Bostock versus Clayton County, also out of Georgia, oddly. Georgia seems to be a hotbed of state-sponsored anti-trans discrimination. And the court in that decision said, this is very simple. Like, it is impossible to discriminate against a transgender person without taking their sex into account. You are punishing them because they want to transition from one sex to another. You are denying them their job or access to benefits because they seek to transition or because they have transitioned. So that is sex discrimination under Title VII. But Scrimetti really kind of made a mess of Bostock. I mean, I think the way that I would put it is that Scrimetti walked back Bostock. At a minimum, Scrimetti created this loophole where I think if you are an employer or a state who wants to discriminate against transgender people, all you have to do is say, I'm not discriminating against you because you're transgender. I'm discriminating against you because you experience gender dysphoria. but both sexes can equally experience gender dysphoria. Therefore, my discrimination is not based on sex. That is the loophole that Scrimetti seems to have opened up. And that's the loophole that the 11th Circuit walked right through in the Lang decision.
So let's turn to one other case of particular importance in the Washington area. That's the Mahmoud v. Taylor case that involved the Montgomery County public school system. Do you want to talk about that one? And also, if you could just expand on what you see as some of the difficulties that public school systems may face in trying to accommodate the court's ruling.
So this case arose after Montgomery County Public Schools started putting books in classrooms that featured LGBTQ characters, including same-sex couples. The goal was to increase diversity, to help students who have LGBTQ parents see themselves represented in the classroom, and to help LGBTQ students see themselves represented. Parents started complaining, and initially Montgomery County allowed for an opt-out system, but it quickly learned that the opt-out system was totally unworkable. It was impossible to warn parents in advance when a teacher might grab Uncle Bobby's Wedding off the shelf and then identify you, and you have to go stand in the hall while I read this book. And so the school system took away the opt-out and said, we just can't do this. Your kids may be exposed to books that feature LGBTQ characters, but we're a public school system and that's the way the world is. So we're just going to do it. The parents sued and they prevailed at the Supreme Court in a 6-3 decision that was so broad that I do wonder if it was a function of the court hearing this case very late in the term and only having 2 months to decide it. Because what the court announced, if you take it at face value, really makes public education untenable in this country. The court said that under the First Amendment's free exercise clause, parents have a fundamental right to prevent their children from being exposed to any material at school that may violate their religious beliefs, or really their parents' religious beliefs. And the court said that that rule holds even when the message that the materials send are subtle and not like overt or even clear instruction. So if a book like Uncle Bobby's Wedding has 2 gay characters who get married, that might be, just the way the world works. But to some parents, it's a sin. And so those parents need to be able to prevent their children from being exposed to those books in any capacity. So the court essentially constitutionalized a kind of don't say gay rule, pioneered in states like Florida, and gave parents a new constitutional right to opt out of their kids being exposed to these kind of books. The reason I say that it's sort of unbelievable is that, as Justice Sotomayor points out in her dissent, like all kinds of religions have all kinds of hangups about things that you and I would never flag as problematic, like women in the workplace, right? Or a woman as an astronaut. Like there are religions who think that women should not be training to go to space and going to the space shuttle. So does a parent have a right to prevent their kids from seeing a book about Sally Ride, like going into space? I mean, if you take this to its logical conclusion, then there really can't be books in public education anymore. And parents have this veto power over the curriculum because, the court phrased this as an opt-out and said, look, it's just about letting a few kids walk out of the classroom. But school districts don't budget for millions of dollars of First Amendment lawsuit defense every year. And if they continue to feature any kind of book that might raise religious parents' hackles, they are going to get slapped with those lawsuits. Like the group that brought this case is standing by at the ready to bring more lawsuits. And so I think what this is going to do is convince a lot of school district lawyers to tell teachers, you've got to purge any potentially controversial material from the classroom, whether it's LGBTQ people, whether it's a story of Hanukkah, because that could offend some Christians, whether it's women in the workplace, because that could offend some Seventh-day Adventists or whatever, like that all has to go because we do not have the budget for another $1 million lawsuit. We want to build an extra bathroom and we can't afford it if we get sued. I think that is the road that the Mahmoud v. Taylor decision is putting us down.
If I recall, during the litigation, there were cases that discussed the difference between younger children and older children and, whether they could be pressured.
Yeah.
And does the court's decision distinguish between elementary school kids and high school kids?
Not really, not in the holding. The case did involve younger children, but Justice Sotomayor specifically brought up older students and said, look, in history class, you learn about all kinds of things that are very controversial and upsetting. In biology, you learn about things that some students might be offended by. Does this mean that those students now have a right to get up and walk out, or have their parents prevent them from seeing chapter 11 of the AP Bio textbook because it talks about human reproduction? And the court's answer was, I think, basically yes. I don't see an age limit on this holding because according to the court, anybody under 18, when put in control of the state, their parents' rights attach. And the parents still have a right to say, my 17-and-a-half-year-old doesn't get to learn about World War II because they might teach about the Holocaust and my religion denies that the Holocaust happened.
So let me ask Vicki, because the JCRC has been active in this area. If you had any questions for Mark?
Well, I was hoping you could talk a little bit about some of the other religion cases.
Yes.
I know that there are some religious school funding
Yeah.
cases. So if you could talk a little bit about that.
So there's an Oklahoma charter school funding case that fizzled out, but is worth talking about because it will be back. We are not done with this one yet. And this was an effort in Oklahoma to establish the nation's first overtly and explicitly religious charter school. So it was called St. Isidore's. And it would have been a church-run school, a school that was owned and operated by the Catholic Church, by the diocese. It would have instructed students in Catholicism. It would have required them to undertake Catholic prayer and to abide by Catholic principles. It would have discriminated against students and parents who don't follow Catholic tenets. It would have been a Catholic school, which is fine for a Catholic school, but it was going to be funded by the state. It was going to be owned and operated by the church, but funded by the state of Oklahoma. And students were going to be assigned to it as their public school, depending on where they lived in Oklahoma. And the state charter board organization embraced it after a very intense lobbying campaign and said, this is the future. The future of our country is Catholic charter schools. And so the Oklahoma Attorney General, who is a Republican, actually objected. He said, this goes too far even for me. He filed a lawsuit, and the Oklahoma Supreme Court blocked the charter school from getting state recognition and state funding and said, under our Constitution, the Constitution of Oklahoma, a Catholic school cannot be directly funded by the state. Then the school sued and argued that the Oklahoma Supreme Court had violated its free exercise clause rights by not allowing it to become an official charter school that was funded by the state. That the First Amendment's free exercise clause requires states to affirmatively establish and fund Catholic charter schools. So at oral arguments, it really seemed like the court was going to agree, but Justice Amy Coney Barrett was recused because one of her best friends was one of the lawyers for the school and actually sort of manufactured this whole litigation. And so the court ultimately divided 4-4. The court doesn't tell us what the votes were when it divides 4-4, but I can guarantee you that Chief Justice Roberts sided with the liberals to create a deadlock. That may have been just an effort to kind of kick this can down the road in an already controversial term. I don't know. I can't read his mind. But I am very worried about this case because I think it's the logical conclusion of a line of decisions that the Supreme Court has issued that have required states to fund more and more religious education, that have required them to allow vouchers to go to religious schools, to allow tax credits to go to religious schools, and to allow other kinds of subsidies to go to religious schools. The Supreme Court doesn't seem to believe that citizens have any interest in preventing our tax dollars from funding the exercise of religions we disagree with. And so if you take that to its logical conclusion, then yeah, there's no problem with religious charter schools. Maybe the First Amendment even requires them. The big test will be if another state tries to set up the system, if Barrett isn't involved, will there be a 5-4 decision saying the doors have been opened to Catholic charter schools?
Right now, there are no such cases percolating.
No. This was the one. This was the test case. I think Barrett disappointed a lot of her friends. She probably got some cold shoulders at Christmas parties because this was sort of like years in the making. But Nicole Garnett was involved and she decided to recuse. Good for her.
So before we turn it over to questions from those here and online, maybe you could just talk briefly about some of the cases that are coming up this term that you think are noteworthy that we should be looking at.
Sure. So I'll just flag two that are really big and very worrisome. One is the Salazar case, which is a challenge to LGBTQ conversion therapy bans for minors. So these are laws in now more than half the states that prohibit licensed therapists from attempting to change a minor patient's sexual orientation or gender identity while on the clock in their professional practice. So obviously there are a lot of caveats in there. If you're a pastor or a parent or a friend, you can still do it. If you're off the clock talking to somebody in a different context, you can still do it. This is essentially a professional licensing restriction that says, we don't think that professional therapists should be trying to tell a gay 16-year-old that he's actually straight. So these have been very popular laws, again, like more than half the states, but they've been challenged under the First Amendment over and over again. And now the Supreme Court has taken one of these cases. And I think it's very likely that the Supreme Court will hold that these laws violate the free speech clause of the First Amendment and strike them down. I think that's where the court has been heading for some time. The court has refused to relax its standards for restrictions on professional speech. It has laid the groundwork for a decision to strike down these laws, and I think that's where we're going. The other case is Louisiana versus Calais, and this is a Voting Rights Act case. Has a very long and twisty procedural background that I won't bore you with. The court actually heard it last term, but then couldn't reach a decision and decided to put it over to this term. And in putting it over, raised the question of whether drawing maps to increase the voting power of Black communities violates the 14th Amendment's Equal Protection Clause. So the Supreme Court will essentially decide whether the Voting Rights Act, by requiring states to give substantial voting power to minority communities, violates the Equal Protection Clause of the Constitution, which seems to me to be kind of an upside down question when the Equal Protection Clause was, of course, first enacted to empower Black Americans and help protect their right to engage in civil society and government. But that is, again, something that the Supreme Court has been building toward in decisions like Shelby County. And I think it's almost inevitable that the court will carve another big hole into the Voting Rights Act.
Thanks, Mark. So I think now we can turn to the audience questions. So let's start. I'm going to alternate between questions, people here in the room and those online. So why don't we first start? If anybody has questions here, just press the button on your device that'll open the microphone.
Push, right?
Yeah,
Okay, great.
and then it'll be green and you don't have to keep pushing it.
Oh, good. Okay, thank you. Thank you. This was fabulous. Are there any cases coming up that you see might be affecting in addition to those that you've talked about generically about religion, that might be affecting the Jewish community?
So there was a decision last term that I didn't talk about, that I didn't focus on too much, that did allow for lawsuits against the Palestinian Authority and Palestinian terrorists, where the Supreme Court unanimously allowed those lawsuits to move forward. That was a very big deal. And I think a correct decision on the merits. We don't have anything like that yet on the docket. I think that we're going to continue to see these troubling religion cases that I would say sort of rope Jews into funding Christian religious exercise. Like that, I think that is the direction that this court has been moving in. I also will flag that there are some abortion-related religious freedom cases where Jewish plaintiffs have argued that the free exercise clause grants them a right to either perform abortions or undergo abortions. And those have been mostly raised in state court, but there's some federal percolation there. And that's, I think, a really interesting test, because there are plaintiffs who genuinely and deeply believe that there are circumstances under which they should be allowed to provide abortions. And some of them are licensed doctors who otherwise would be able to, but for state laws that stand in the way. And so they argue, like, look, if a corporation can refuse to fund its employees' IUDs through its health insurance, why can't I, provide a health preserving abortion to a patient who I think needs it if that's my religious belief? That's a really big one that I think is going to test just how consistent the Supreme Court is going to be about religious freedom, and whether it's going to stand by neutral principles or sort of carve out special rules that only apply to conservative Christians. And then the last one I'll just flag is that these religious symbols in public life cases keep percolating up. And just a few years ago, the Supreme Court allowed the Peace Cross in Bladensburg, which we've probably all driven past at some time, to stand. I think the court is going to really abolish all restrictions on governments putting up religious symbols, including crosses and mangers and other symbols of Jesus and Christianity in town halls and in public squares. And along with that, I think the court will continue to roll back protections against Christian prayer, both in government meetings and at government bodies, and quite possibly in public schools. So those are some very concerning areas. To be clear, none of them are on the docket yet for next term, but it's early still, and I think a few of them could hit it soon. Yeah.
Before I go to the online, I want to make just two comments on what you said. One is on the Jewish plaintiffs bringing abortion cases. I want everyone to know JCRC a couple of years ago did a whole round of webinars on reproductive rights. One of which was a bunch of rabbis, one from each denomination, talking about Jewish law and abortion. So if you're interested in looking at those, they're on our YouTube channel. I'd be happy to send you a link to them. Also on the funding of religious schools, it's an interesting topic, I think, for the Jewish community. The Jewish community has long debated sort of not supporting a Catholic school, but ways in which federal dollars could be used or state dollars could be used, whether it's for security or other things, still going to religious institutions. And so it is an ongoing
but
debate.
for a secular purpose.
It is an ongoing debate within the Jewish community,
Totally. I'll say that there have been amicus briefs filed by Jewish groups in a lot of those cases, and a lot of them do sort of draw the line between money going towards secular purposes and money going toward religious exercise, right? So, and there was a case where a state wasn't giving a religious preschool money to repave its playground. And that was one area where some Jewish groups said, look, we should be able to get money to do this, like we're educating children as well. But then there was a case where the school wanted money to indoctrinate students in Christianity. And there was a flip where a lot of the Jewish groups that had weighed in on one side said, we don't think this should be happening. And so I think that there is a principled line you can draw there, but it is certainly a nuanced issue that deserves sort of those clarifications.
Yeah. Okay, so we have a question here about you square Spermetti with Plessy versus Ferguson.
I mean, I think it's the right question to ask. I do think that Spermetti raises the specter of separate but equal in a lot of ways, right? Because what the court essentially did was say, well, you're discriminating against boys and girls in the same way. And because you're imposing an equal burden on both of them, then it's not actually discrimination at all. And that was the reasoning of separate but equal. And as with separate but equal in Plessy, this sort of sophistry occludes the real purpose of these laws, which is to diminish the lives and health of transgender people. And so I think that the court embraced a pretty obvious smokescreen in deploying this illogic, I would say, that does ring in the same register as what the court did in Plessy versus Ferguson. But, there was a lot of controversy around bringing that case, Spermetti, to the Supreme Court in the first place. This is a court that is not supportive of LGBTQ rights. That's what we should expect of the Supreme Court. And so I think progress in this area is going to have to come through the democratic process. It's just not going to come from the federal courts, as the Lange decision yesterday clearly illustrated.
So no active cases I'm aware of, but can you discuss your thoughts on the blurring of the lines, if you will, between like military and regular traditional law enforcement?
Well, they're barreling toward the Supreme Court now because Judge Charles Breyer in California, who is the brother of Stephen Breyer, and they do sound the exact same, which I find sort of uncanny, issued a decision, I believe, last week, holding that the Trump administration had violated the Posse Comitatus Act, which is the law that generally prohibits federal troops from performing domestic law enforcement within the United States. So Judge Breyer actually held a trial, which I really admired, where he sort of hauled in the key decision makers in this surge of federal troops in California and got to the bottom of what they were doing. And the government had claimed that they were just protecting federal property and protecting federal police, which everyone agrees they're allowed to do. They can back up a legitimate federal operation. But Judge Breyer said they're doing way more than that. They're engaging in like beat policing. They are walking the streets, finding people to arrest for minor crimes. They are taking the place of the LAPD and LA County sheriffs. They are doing this work that is so clearly prohibited by the Posse Comitatus Act. And so he issued an injunction that I think it's fair to say it's a fairly narrow injunction that says they can be here, right? They can be deployed, they can protect federal agents and federal property, but they cannot be used for domestic civilian policing. We'll see what the Ninth Circuit does with that, but I do think that case may well land on the Supreme Court's docket.
Well, I mean, and I know there was a lot of discussion about this topic on one of your recent podcasts, right? So that was very informative, by the way, very informative. But with regard to the ship being blown up, the drug smugglers last week, that's sort of like an extension or a ratcheting up, if you will, on this. So what are your thoughts on, on that issue? I mean, if you follow that to its logical conclusion, I hope I didn't hear this on your podcast, and I'm not just repeating back what you heard. But the logical conclusion is, well, if you can go just kill terrorists anywhere, like they go shooting people down on the street here in this country too, which that seems like a line in the sand. Maybe.
So, I mean, I generally abide by the principle that if the president wants to blow up something or someone outside the United States, the Supreme Court will always let him. The Supreme Court is not going to stand in the way of the president's vast constitutional power to blow stuff up. I think that's a pretty clear through line of its jurisprudence here, right? I don't think that that's necessarily constitutionally correct, since as we all know, the Constitution gives Congress the power to declare war and only makes the president commander in chief of an army that Congress chooses to create and fund that cannot be funded more than 2 years out, because the founders were actually very worried about a standing army. But setting all of that aside, as long as this kind of mischief is happening overseas, like I don't think the Supreme Court or even really any federal court is going to try to stop it. I don't think it's going to be like Justice Douglas trying to stop the Cambodia bombing in the 1970s. Like I just don't think federal courts are going to try it. If the president starts blowing up people in the United States, that's a different question. And I would argue that he's sort of testing the waters there with the illegal detentions and deportations of Venezuelan migrants accused of being members of Tren de Aragua. And I know this has been quite a doom and gloom talk, and I apologize for that. There are some cookies for those of you in the room who need like a sugar burst after this. But this is one area where the Supreme Court has actually done the right thing, right? So in April, the Trump administration had rounded up all of these Venezuelan migrants and was putting them on buses to an airport to deport them to a prison in El Salvador, where none of them had even been before, where they would be held indefinitely. It's like a torturous prison for terrorists. It was horrible. And the Supreme Court issued at like 1 a.m. an order blocking the deportation of these migrants and said a few weeks later, very clearly, that their constitutional rights had been violated. And so I think that the court is still drawing a line at the grievous, overt, and like mass obliteration of due process rights of individuals within America who indisputably still have a right to due process. We haven't crossed that line yet.
Well, but I mean, isn't there a difference between blowing stuff up outside of the borders? It's just a bright line for you. Like, no matter what he's blowing up, he could blow it up, even if they're just everyday criminals as opposed to like militants. Okay.
And yes, and I think that the reason why is twofold. It's not just that the conservative justices think that he has the power to do so. It's that they probably don't think they have the power to stop him. And that's been a theme in a lot of these decisions, including the CASA decision, right? Where sometimes the justices, and Barrett said this in her majority opinion, she said, we, the judiciary, do not have the constitutional authority to right every wrong committed by the other branches. And there are instances in which the other branches will do something illegal where we can't stop them. And that's just the way that our system is built. And so I think that in a case like that, I would be aghast. I don't mean to be too flip about this. Like, that bombing was illegal and very bad, as were previous drone strikes of American citizens abroad that other presidents had undertaken. I think that those are all really grave injustices. But I think that the courts, and especially the Supreme Court, that they want to make clear, like, even if it's wrong and unlawful, these are military operations that we just don't have the power to stop.
That actually surprisingly leads into my question. The Supreme Court seems to repeatedly say, like, we're not one of the political branches and we don't exercise political power, but the decisions, we take the facts and we apply the law and we reach a decision. But more recently, it feels the other way, where they're coming up with a decision and then reverse engineering the law to fit politically what they are deciding. But more recently, do you get a sense that some of the justices are potentially trying to more overtly exercise their political power by doing things like going to the press or things like that, kind of breaking that seal of what happens behind the closed doors of the Supreme Court?
Do you mean like liberal justices,
That's
like
actually,
blowing
that's
the
actually
whistle?
what I mean. Yeah.
So
this is what happened, actually.
I think if any justice would do it, it would be Justice Jackson. I have like a kind of running bet with my friends. When will Justice Jackson use the term MAGA justice in a dissent? Like, she has been getting closer and closer to just burning it all down. And her dissent in the CASA decision and her dissent from some of these shadow docket decisions have gotten really, really close to saying my Republican colleagues are hacks and you should have no respect for them. So I think it is possible that Justice Jackson may cross that line by the end of Trump's 4 years at the latest. Like, I think that she is moving in that direction. Justice Kagan and Justice Sotomayor are still playing good cop. Like, they still moderate their rhetoric, even in Justice Sotomayor's dissent, where she was like, you guys are racist on Monday. She still moderated her rhetoric to ensure that it wasn't personalized. Whereas Justice Jackson is sort of personally insulting the conservative justices as being partisan hacks. So, if Justice Jackson were listening, I would offer her my direct line and say I'm happy for any scoop that she chooses to offer. I do think that it's healthy for the public to get a look behind the velvet curtains. I don't think that we are there yet, but if we do start seeing major leaks that could only come from the justices, it won't be hard to guess who might have provided them.
I think we can take one more question because we're gonna have to wrap up.
Yeah, so there's a question to add, can you talk about the tariff cases?
How much time do I have?
Let's see, I think about a good 5 minutes.
Oh, really? Okay.
Maybe 3.
Yeah. So I guess this is like the theme that we've been hitting on over and over again about, does the Supreme Court have any consistency? Like, the tariff cases are sort of the final boss of that question, right? Because here is a statute that Trump is invoking to issue hundreds of billion, eventually trillions of dollars worth of tariffs that will be paid by American consumers, that will come out of our wallets. We, unlike the president, I'm sure we all understand how tariffs work. It's an emergency statute that doesn't mention tariffs or taxes or duties or any of this other stuff that you would expect a statute to talk about if it empowered the president to unilaterally impose tariffs, right? Trump has invoked it to impose the tariffs anyway. The lower courts have ruled that that was unlawful, and they've ruled that it wasn't a particularly close call. They have said that there are statutory frameworks that the president could use to impose tariffs. Everybody agrees on that, but they are much more limited, and they have a time duration that the president can't exceed. And this is just a kind of backdoor way to impose tariffs without congressional authorization. The president can't do that. So this has now been granted by the Supreme Court. The Supreme Court will hear arguments in this case the first week of November. And I mean, the reason I say that it's like the ultimate test of the court's consistency is that for 4 years of Joe Biden, the Supreme Court wielded something that it called the major questions doctrine to strike down any big policy item that Joe Biden wanted to do through executive action. The eviction moratorium during COVID, the vaccine or test mandates, the student loan forgiveness plan, the clean energy plan that he tried to impose through the EPA. The Supreme Court blocked that stuff over and over again and said, we understand that if you read the text of these statutes in isolation, it arguably lets the president do this. But we think that what he's trying to do involves a major question of political and economic significance that needs to be affirmatively and explicitly approved by Congress before the president does so. So that really hemmed in Biden. I mean, we would be in a different place right now if the Supreme Court hadn't done that to Biden over and over again. This tariffs case is like the paragon of a major questions doctrine case. We have a statute that if you read it really broadly, if you squint and you have 2 beers, you might be able to make the argument that it authorizes the tariffs, right? But if you're really serious and you're being a real lawyer, it does not allow the president to unilaterally impose unlimited tariffs. Like it's just not, that's not what it was designed to do. That's not what Congress intended to do. Any method of statutory interpretation, it doesn't allow it. So will the Supreme Court invoke its beloved major questions doctrine against a Republican president and strike down one of his, signature policy items? Or will it allow him to get away with this and essentially say that the major questions doctrine only applies to Democratic presidents? I don't know. I would not put money down on this. I'll tell you, not to brag, but I can almost always guess the outcome of these cases. I've got a pretty darn good record. I'm not guessing on this one, at least not until oral arguments, because I really don't know where the court will swing. I think it could be an opportunity for the conservative justices to shore up their credibility and say, look, what's good for the goose is good for the gander. But I also think that the conservative justices love giving Donald Trump wins. And this could be another big win in his column that they wind up being happy to give him.
Check with you in November.
Yes, that's right. After arguments. Yeah, that's right.
Well, I think we're going to have to wrap it up. Mark, thanks again for doing this. It's the 2nd year in a row.
Thank you. It was a pleasure. Thank you for hosting me and for giving me lunch. It was really lovely. I love the pickle. Thank you for including that.
We always offer our speakers a pickle on request. And we'll announce our next program soon. And I look forward to seeing all of you then.